Hello, my name is Michael B. Hyman, and I am the chair of the Scribes Book Award Committee. Our 2020 Book Award winner was Intimate Lies in the Law by Professor uh, Jill Elaine Hasday. It was the book that we felt was the best work of legal scholarship published in 2019. Professor Hasday is a distinguished McKnight University professor and the Centennial Professor of Law at the University of Minnesota Law School. She teaches and writes about anti-discrimination law, constitutional law, family law, and legal history. She graduated from both Yale College and Yale Law School. And after law school, she clerked for one of the great federal judges who never became a justice on the Supreme Court, Judge Patricia Wald of the United States Court of Appeals for DC Circuit. And then she immediately went into teaching, beginning at the University of Chicago and now at University of Minnesota. This is her second book. Welcome.
Thanks for having me.
Oh, well, glad to have you. First question is that tell us generally what your book's about.
Intimate Lies in the Law is about deception in dating, sex, marriage, and family life, and the law's response to this duplicity, which is usually to deny remedies to deceived intimates and protect their deceivers.
How did you come about writing this book?
Well, I want to say at the outset that I was not inspired to write this book by my personal life. In fact, the dedication to my book reads, "To my loved ones, you didn't inspire me to write this book."
I saw that. I noticed that right away.
I wanted to make that clear at the outset. This book was inspired by my intellectual life. Early in my career researching family law, I came across this case where this woman had married a man who she thought owned a chain of shoe stores. And after the wedding, she discovered that he had lied to her. And in fact, he was a clerk in one of the stores that he claimed to own. And I was shocked at the time, both at the magnitude of his deception and also at the court's refusal to give her remedies. And I always just kept that in mind as something I wanted to go back to.
And how long did it take you to write the book?
It was basically 5 years. I have a very intense research process and it takes a long time.
We're talking about research. How did you go about researching the book?
I think research is an iterative process, so you can't come up with all your strategies in one day. So I started with some questions I wanted to investigate and sources that I wanted to look at. And then looking at those sources gave me more ideas. And then the process of writing itself helped me realize, oh, there's some other things I need to investigate. Also, what was great about this project is that you can talk about intimate deception with anyone inside law and out. And a lot of times those conversations would give me more ideas about things I wanted to look at. I think the key with research is you have to come at it more than one time. So there's no West Key site intimate deception. I had to think a lot of different ways and over a lot of time about how I was going to find the cases I wanted to look at.
Now, one of the things about your book that we noted was its uniqueness. I mean, this is a topic, as you say, that was hidden in plain sight. Why is that?
Okay, so everyone knows that people sometimes deceive their intimates, but people just haven't systematically thought about it or considered how the law responds to it. And I think in some ways, its very everydayness keeps it hidden, even from lawyers. Another reason I think it's hidden in plain sight is that usually the law denies remedies. And as a profession, lawyers and certainly law professors tend to focus on cases where plaintiffs win. And it seems more exciting. But that really misses a lot of what the law is doing. A lot of times, the way the law operates is by refusing to give you redress.
Right. First, why don't we explain who is an intimate? Because it's broader than one might think.
I include romantic, sexual relationships and family members. One of the things that's interesting about intimate deception is that courts tend to define intimacy very broadly in the context of romantic and sexual relationships, including people who really didn't know each other very well or for long. In contrast, in the family context, they're very narrow about intimacy. So they'll include parents, children, and spouses, but they treat, say, siblings or cousins as if they're unrelated. So it's a very unique definition of intimacy.
How did that develop? That dichotomy?
Oh, well, I think in terms of family law excluding siblings, my first book, which was called Family Law Reimagined, one of the themes of that book is that out of the common law tradition, family law is really focused on two poles, the parent-child relationship and the marriage relationship, and to have remarkably little to say about other family relationships, including those that can be very important over a lifetime, like siblings. And I think intimate deception is just an example of that in action. Just family law tends not to focus on relationships other than marriage and parenthood.
What began your interest in family law?
I consider myself an anti-discrimination scholar. That is my main interest. And then as I was thinking about areas I wanted to explore and courses I wanted to teach, family law always just struck me as an important site of discrimination and a fascinating arena. In the general legal hierarchy of subjects, I think family law is usually placed towards the bottom. But when you think about what people actually care about and what is actually at stake in people's lives, it's family law.
I agree. I sat in the domestic relations division of the Circuit Court of Cook County for a year, and it was a special year. I mean, I thought it was extremely interesting, and the situations, they can't make them up on TV. I mean, it's much more interesting than that, the real lives.
Oh, yeah.
What do you think are some of the common misconceptions about intimate deception?
Well, I think courts and commentators tend to blame people for being fooled. And there's a lot of reasons for that. Events tend to seem more predictable when we're viewing them in hindsight and we already know what happened. It's comforting to believe that only the particularly stupid and gullible can be duped, because then we're all safe since we're also smart and savvy. But detecting deception is much more difficult than we like to believe, perhaps especially deception from an intimate. Even if you are suspicious, strong social norms urge us to trust our intimates and not investigate. And even if you want to go ahead anyway, it's hard to investigate someone without the investigation coming to light and jeopardizing the relationship. So there's practical obstacles to investigating without the person spotting you. And there's legal obstacles to investigating without consent. One of the ironies is that courts tend to blame intimates for not investigating when the law itself makes investigation much more difficult. So there's laws against searching through someone's emails or credit reports or tax returns, and for good reason.
You think some of this really grows out of the fact that the law has always been discriminatory against women?
Right. So I don't think the way that sex discrimination or gender bias operates is that deceived women are less likely to get remedies than deceived men. But I think in general, one reason that the law hasn't been very interested in this arena is that it is associated with women. There's an assumption that men are the ones who deceive and women who are the ones who are deceived. This fits into a general pattern in tort law of undervaluing emotional injuries compared to financial and physical ones. I think one reason for that is this idea, is its association with women.
Did you find your research that it was more likely that a woman would be deceived than a man, or did you see the cases being about equal?
I guess I want to say two things. One, it's very clear to me after writing this book that every group, every demographic deceives, right? So the idea it's the exclusive purview of men or women is just not true. At the same time, if you look at the cases, it's certainly the case that vast majority of women who file, of plaintiffs who file are women. I think some of this might be that maybe certain kinds of deception actually women are more likely to experience. It might be more culturally acceptable for women to complain about deception than for a man to admit he's been duped.
Yeah, right. Well, what do you hope readers get out of your book?
Intimate deception can cause enormous injury, both emotional and financial and physical. And the law now routinely denies deceived intimates access to the remedies that are ordinarily available for deception. So I hope the law focuses less interest on protecting deceivers and extends more help to people who are deceived. And I think the only way that happens is for more people to really think systematically about how the law regulates intimate deception.
You were pretty tough in the judiciary throughout the book. As a judge, I noticed that. So what do you think the judiciary, why have we come up short in this area of the law?
I think the premise that court should not offer remedies for intimate deception is taken as such common sense, is so assumed that it's really assumed more than questioned. Courts start with this baseline presumption and they really don't explore it.
Well, but that assumption, first of all, the law is mostly made up by men, and judges until quite recently were mostly men. So does that have anything to do with it?
Yeah, I mean, and certainly some of the older cases are very explicitly gendered. So there's this one case from the 1930s. This man lies to his fiance about everything. He claims to have a job he doesn't have, assets he doesn't have, it's sort of every single detail of his life. She marries him. He conceals that he's an alcoholic, all this stuff. She marries him. She tries to escape the marriage. And the court says, no, you can't. He did nothing more than the rooster strutting in the barnyard, And in fact, some courts have said the future of heterosexual reproduction depends on male deception to get women into bed. So that's highly gendered. It's a remarkable claim. But I think you can see gender operating in many of these cases. And that is one of the things that explains the lack of remedies.
Well, I could just tell you one little story. When I was in domestic relations, I think I had the shortest marriage in history, because I asked the woman who was asking for the divorce, I said, when did you get married? And she says, August 1st. And I said, when did you leave the marriage? She said, August 1st. I said, well, that's the same day you got married. She said, yes, we got married at the courthouse. We went to a hotel. I found out that things weren't what he said they were. And we left each other and haven't seen him since. And it's 6 months later. So I granted her the divorce.
But, good. I mean, there's a lot of short marriages, but yes, that's amongst them.
You really got to see. I didn't get into it, but it happens. What surprised you in writing this book, if anything?
Well, when I started, I was surprised all the time. This person has a secret second family. How do they manage the logistics? As I said at the beginning, I've had a very smooth personal life. But at this point, for better, for worse, nothing surprises me anymore. Anything you can imagine, anything that might matter to anyone in an intimate relationship is the subject of intimate deception. The list is just endless.
As a judge, I can agree with that, having sat there in family law and in other courts where there was deception and lies. Can you give us some insight into your writing process?
My writing process is very research-based. So I'm not someone who writes it all out and then looks for supporting evidence later. What I do is I start with a rough outline of what I want to write, and then I make it more detailed and elaborate as I read sources and learn more. So by the time I sit down to write, I actually have a very detailed sense of what I want to say, point by point. And then, of course, the process of writing helps me make take my thinking to a much more thorough level. Then when I'm done, I revise multiple times, looking at both how can I improve the argument, how can I improve the writing. I'm also a big fan of sharing my work with colleagues. I think it's very valuable to get their insights and questions. How do they read the words you put on the page? It's not always how you think they would be read.
One of the things that Scribes we often talk about is revision. You said you go through several reiterations. How does each iteration, does it change in what you're looking for? Or, I mean, sometimes people, when they edit, they do it in different steps, or do the whole thing at once, or how do you go about it?
I know that some people do. This is where I'm going to look at the writing. This is where I do everything all at once, because I feel like if an insight comes to you, I certainly want to capture it. But after each chapter, I'm reading that over many, many times while it's still fresh before I would move on to the next chapter. And then I also, every time I have an opportunity to sort of be away from my desk, like before when we used to take plane trips, when I would take a plane trip, I would read the whole manuscript because it's a chance to sort of be a little further away from it. And then, of course, when it's completely done, I would read it again. How does it hold together? Are there places I can improve? Or is there things that are repetitious that I want to eliminate? I think it's really important to leave time for revising, because revising is what makes it better. Or, I mean, maybe some people, the first moment they write it, it's excellent. But for me, I'm revising it to get it much better than it was at the beginning.
I think there's some judges that think that, but other than that, it's not a good idea. It's not a good idea. What were the challenges in writing this book, and how did you address them?
I think a challenge in writing anything is figuring out what to include and how to structure the piece. And that's another reason why I outline first, is that I want to know before I start writing, what is the basic structure? Where do my sources lead me? What does it make sense to put together? I don't think figuring out the structure is something you figure out in one day. You have to go at it many times. And it's better, if you can, to do that before you actually start writing, which takes a lot of time.
So did you, I mean, since you're always revising and adding, and your structure is in flux, is really what you're saying. You have what, 6 or 7 chapters?
Right. So, but when I started the book, when I first sat down with like my very rough outline, I had, I think, like 12 chapters thought of. And then but I knew that that was too many chapters. So I had 12 chapters, but I didn't have a sense of how am I going to combine them and what am I going to put together. And then as I was doing the research, I figured out, oh, this actually makes sense, not as a separate chapter, but as part of this. And I figured out how to put it together. And then I didn't, a little bit, I revised the basic structure of the book in the revisions, but I actually worked on that structure so much that the basic structure, like the chapters, what is each chapter going to say, that was basically set. And I was more about exactly what's the argument going to be, how can I write this in the clearest and most effective way possible. But I think structure is something you really have to work on over time. And then if it's not working, you have to redo it.
Well, I mean, one of the things that the committee looked at was the fact that it was such a smooth read. I mean, it flows from one chapter to the next and builds until
Thank you.
What do we do about this problem, right? So I think you did a very good job in approaching it. What did you find the most difficult part of writing, and how did you overcome it?
I think the hardest part of writing is facing a blank page when you don't have a clear enough idea of what you want to write. And that's why I take so many notes, because I begin writing. By the time I begin writing, I have a very good, I'm not facing a blank page. I have a very good sense of what I'm going to write. Now, of course, in writing, I'm elaborating and I come up with new ideas, but I'm never facing that blank page of what am I supposed to say now? And then once you have those notes, just write it. You can always make it better later. You're going to be so happy you put it on the page. And when you come back to it, it's so much nicer to revise than to be starting from scratch.
How did you keep your notes on a computer, and then you could search them, or and with
if you want to get into the nitty gritty, yes. So I have a big outline on my computer, which is not, it's actually a combination of my notes, but it's also like quotes from sources. So it really is, I'm going to say this, and sometimes I'll draft a few sentences as I'm thinking of them, and then I think I'm going to use this example, and here's this quote, et cetera. So it's all on the computer. I save all my sources as PDFs, where they're all named in a way I can find them. And I think that's very helpful. I have printouts also, but it's nice to have everything on the computer. So then you don't have to remember exactly what file you put it in. Everything is very searchable. That time you spend in organization pays off in spades later. You want to be set up so that you're not searching around for things, so you're not losing things. Because in this book, I had thousands of sources. You have to be organized with it.
Yes, you do, which is another impressive thing. What did you learn from doing your first book, which was published in 2014, that then helped you write the second?
I learned that I love writing books. I find it extremely gratifying. I think also the thing about a book is it's just like anything. You just sit down and do it. It's much more work than you think. So some people had said to me, writing a book is like 3 law review articles. I don't think that's true. I think it's just much more work. It's a much bigger project, and
10 law review articles.
Revising the whole thing. But it's very gratifying. And I think what's so nice about a book is it gives you access to people who are outside of the legal academy. And especially with this book, I can talk about intimate deception with everyone. It's a very accessible topic, and you hear, amazing stories all the time. I think a book just gives you that.
What advice do you have for legal writers?
I have 2 pieces of advice. The first is give yourself enough time to reflect and revise. It's much better to spend 2 hours a day for 5 days than to spend 10 hours the day before something is due. You want to give yourself the opportunity to come back at something with fresh eyes and to have had your brain thinking about it in the background as you do other things. Second thing I'll say is I think people make a mistake and they think legal writing is fundamentally different from ordinary writing. so that when they sit down to draft a piece of legal writing, they model it after what they imagine a 19th century will would be. And that's just not a good strategy. You should try to make your writing as engaging and accessible as possible while still making your legal arguments. You want to draw your readers in. Most people, they're reading it, they don't have to read it. You want them to want to read it. And that's something you should keep in mind as you're writing it. What can I do to make it worth this person's time to read what I've written?
Those are two great pieces of advice. And since you never practiced law, but you know that lawyers wait to the last minute. So you already know that.
I think procrastination is a bane and has many, many, many downsides, including one, you don't have enough time, but also it's so anxiety producing. If you write it at the beginning, you're calm, but if you don't write it, it's hanging over you. It's making you not feel relaxed, and you still have to write it. You don't get away with anything.
No, in the appellate court, what we get is continuances after continuances.
Right.
You know, give us more time. And finally, we just say, this is it.
That's it, right.
And they still do it the last minute, right?
Right, of course.
That's the way it goes. Did anything surprise you about the reaction to your book?
No, I mean, it's been a mix. So some people I think are on board. They're completely convinced. What can we do to lobby the legislatures? And obviously, I love that. Some people are quite are hostile, and not always, but sometimes that reflects their own personal experiences. They don't like someone who's suggesting that maybe some of their own behavior would be, questionable or inappropriate. But I don't think. I'm not imagining that you write one book and the world changes. The idea is that it's to start a conversation and get people thinking about it. And I think when many people look at these cases together, they think, actually, the law's assumption that there shouldn't be remedies doesn't quite make sense. Because what I'm advocating here is basically that deceived intimates should have access to the same remedies they would have if they were deceived outside of intimacy. So you still have to prove a claim for battery, or you still have to prove a claim for misrepresentation. It's all the ordinary things a plaintiff has to prove. It's just that the fact you were deceived by an intimate isn't a categorical bar. So I'm trying to take advantage of the structure the law already has. And I think to many people that makes sense. I'm not saying everyone, but to many people that makes sense.
What kind of legislation are you proposing?
Generally, it's an interesting question. Generally, this hasn't been done through legislation. I mean, I think that there are opportunities for legislation in particular. So in addition to wanting to give plaintiffs more remedies when they go to court, I think that legislatures can really do a lot of good in thinking about how to regulate intimate deception better before any litigation begins. It's much better to avoid injury than having a remedy after the fact. So for instance, legislatures could look for opportunities to make it easier to discover whether an intimate has deceived you in cases where that wouldn't jeopardize privacy, liberty, or security. So one idea I have in the book is that states now have public databases of marriage and divorces. And I think states should consider coordinating those databases together. I don't see that as much of an infringement on privacy because these are already public records. And putting it together would make it easier to discover whether someone is as unmarried as he claims to be. So that's an example where legislative action, I think, can help people discover on their own that they're being deceived.
Do you think there's a way for judges to get on board a little more than they have?
I think judges should start with the assumption that a deceived intimate will have access to the ordinary remedies they would otherwise have. I think this has a lot of advantages. It promotes compensation, deterrence, recognition that intimate deception can be wrongful. It doesn't put judges in the business of having to decide what's an intimate relationship and what's not. And as I said, judges tend to be very broad in defining romantic relationships and narrow in defining familial relationships. It allows parties to build on the existing bodies of law. And I just think it's a very straightforward approach. You're not coming up with any new torts. It's just allowing people to pursue the torts that exist. I don't think that every deceived plaintiff is going to be able to win, just like many plaintiffs lose, right? It's just they can pursue their claim. That's all I'm asking.
What did you learn that you hadn't known before?
Well, I didn't really understand how and why the law regulated intimate deception until I actually did the research and found out. So for instance, When I started, I thought courts might deny remedies to deceived intimates because they just thought intimate deception was too trivial to be worth the court's time. But in fact, many courts declare that intimate deception is crucial, even, as I said, going so far as to say the future of the human race depends on the law leaving intimate deception prevalent and untrammeled. I just didn't know that. I mean, I think it's a mistake when you start a book to think, oh, I already know everything and I'm just writing it up. You're not. Like, you know some things enough to say you want to write the book, but now you're going to learn more.
Well, one of the things you say in the book about no-fault divorce had some effect too in this area.
Right. So no-fault divorce, one consequence of no-fault divorce is that there's fewer intimate deception claims than there used to be, because it used to be that one important reason why people would go to court claiming they had been deceived is they wanted to escape an unhappy marriage and they couldn't get a no-fault divorce. Now with no-fault divorce, you don't have to say any reason why you're seeking a divorce. You can just get a divorce. But some courts have said the existence of no-fault divorce means you shouldn't have a remedy when your spouse or your fiance deceived you. I don't find that argument unconvincing. No-fault divorce was an important advance for freedom and equality, but I don't think it immunizes you from all the harms you might inflict on a spouse. If that was the case, then the existence of no-fault divorce would mean that you can't sue for battery when your spouse beats you because your only remedy is to get a divorce. That's unappealing, and it's inconsistent with the fact that virtually all states have eliminated interspousal tort immunities. You can sue your spouse for tort now.
Right, right. And you talk about that in the book.
Right.
Quite thoroughly. So if I also wanted to mention that you're on Twitter, and it's at Jill Hasday, right?
Yep.
And you have, as of the time I checked yesterday, you had 2,306 followers.
Okay.
After this, you may have a lot more, I hope. And I did go through, and I found your comments very interesting. And it's a continuation of the conversation that you began in the book and in your first book, basically.
Yeah,
and
yeah.
areas that you're interested. And you've testified recently before Congress a couple of times.
Yeah, I testified before the Minnesota House. They're considering a bill to prohibit employers from asking job applicants about their pay history. And that's a measure that would, I think, help promote equal wages between men and women. So I testified in favor of that. And then I testified for a congressional commission that was making recommendations to Congress about how to reform the selective service system. And I explained why I think that mail-only registration is unconstitutional.
I assume you were a big fan of Justice Ginsburg.
Yes, yes.
And did she have any influence on your career?
I find her very inspiring.
Before we leave, you said you like to write books. You've written two. I assume there's one on the in your mind or in the works. Can you give us a hint?
I'm currently working on my third book, which right now is entitled tentatively We the Men. And it's about how America misremembers women's struggles for equality. So basically two themes. One is when courts or politicians or textbooks reflect back in American history, they tend to erase women. They just don't mention it. So like the bicentennial doesn't talk about women. And then when they do talk about women, they often say equality's been achieved. One thing that's interesting about this is those statements start in like 1906. I mean, before women can vote, they're already saying sex discrimination is in the past, equality's been achieved. And then I show how this has consequences. So courts, often when they're denying women rights, the argument that will give is women don't need this right, they already have sex equality. So it kind of has a punch. So I'm working on that right now and I'm enjoying myself.
And just on that topic, there's also been a big difference in how Black women have been treated in history compared to white women.
Right. And I think actually they're very linked, because when people are making the argument that women never had to fight for anything, they got everything they wanted, they've been on a pedestal, either explicitly or implicitly, they're thinking about white women. Right. It's not plausible to say anyone else was on a pedestal. So these stories where it's a very consensual account where women easily got what they wanted, men just gave it to them. I think it's implicitly they're really thinking just about white women.
Well, we'll look forward to that book, and hopefully, it'll come to us at the Scribes Book Award Committee. I know, again, congratulations on your recognition on this book. It's a highly readable book, which is another reason you received the award. And again, it was unique and the scholarship was outstanding. And I look forward to your next book. So thank you very
Thanks so
much.
much. I really enjoyed this conversation. Thanks for having me.
Thank you.